SJC-13416, Anthony Gattineri v. Wynn MA LLC.
Good morning, Chief Justice Budd and fellow justices. May it please the court, Kelly Jordan Price here on behalf of Anthony Gattineri, and with me are my co-counsel Michael Connolly and Jay LeBlanc. As the court is well aware, before the court are two questions that have been certified by the First Circuit to this court. The first question being whether the San Diego Agreement is unenforceable because it violates the Massachusetts Gaming Statute, specifically Section 21. And the second question is whether the San Diego Agreement is unenforceable because it violates public policy. I'd like to describe what this case is actually all about, because the briefs raise a number of issues that are somewhat irrelevant, we would submit. This case is about the enforceability of an agreement, a private agreement that was entered into between Wynn and Anthony Gattineri. Importantly, for purposes of the certified questions before the court is to assume that that San Diego Agreement was validly formed. The San Diego Agreement was an arm's-length agreement between two private parties. Under its terms, Anthony Gattineri agreed to sign a certification of ownership that Wynn needed in exchange for a promise from Wynn to make Anthony Gattineri whole. Anthony Gattineri was under absolutely no obligation to sign that certification and actually had a number of reasons to refrain from doing so, including the fact that the Gaming Commission required criminal referrals in connection with approving the Ninth Amendment, and Anthony Gattineri had every reason not to sign that certification. The San Diego Agreement was entered into 6 months after the Ninth Amendment to the option agreement between Wynn and FBT was approved by the Gaming Commission. The San Diego Agreement does not alter or amend that Ninth Amendment at all, or in fact—
Well, but I mean, the big picture, I understand it's a contract between two private parties, but it's a contract related to an issue that's front and center to the Gambling Commission, which is whether their decision not to allow someone they were worried about getting basically a casino premium was permissible. And the license was granted based on that issue, wasn't it? So you can't we can't look at this out of context, right? We have to look at it in the context which we're doing. So I just feel like you should confront 21 and confront the public policy issues directly, because I don't think you're going to avoid them.
So with respect to Section 21, and as I understand it, there's two issues. There's 21B and 21C. 21B talks about the transfer of an interest under a gaming license. One thing that I think is fairly remarkable, Your Honor, is the Gaming Commission submitted an amicus brief in this case. There's an issue that they were completely silent on, and that is whether or not this San Diego Agreement violated the Gaming Act. I submit to the court that if the Gaming Commission, who is charged with the enforcement of that statute, thought there was a statutory violation, they would have discussed it in their brief.
Can I ask you to go back to that statute, because that was interesting, 21B. Why is this San Diego Agreement not a transfer of a pecuniary interest under a gaming license?
Your Honor, it's not a transfer of any interest under a gaming license for a number of reasons. One, when the San Diego Agreement was entered into, there was no license at all. So there's no transfer of anything under a license. With respect to the language of 21B, it talks about, and for good reason, it talks about the transfer of an interest, either the gaming license or an interest thereunder, that needs to be approved by the Gaming Commission, because the Gaming Commission needs to determine whether the transferee of an interest under a gaming license is suitable.
But I'm confused, though. Sorry, I didn't mean to cut you off, Justice Wellwood.
No, go ahead. I think you're going to say what I'm going to say.
Well, go ahead then.
No.
So,
I can still see.
I'm confused, though. The payment, Wynn gets a license. Your client doesn't get paid until after the license. There will be no payment, right, unless there's a license, right? So I'm trying to understand, I understand your timing point, that 21 only deals with the licensing process, but the payment itself is going to occur and only occur if Wynn gets the license, correct?
That's correct, Your Honor, but that's a timing issue. It's
Well,
not
But then
transferring.
isn't it, as Justice Wendland was just talking about, a transfer of a pecuniary interest related to a gaming license?
But that's not what the statute uses the term under a license.
Well, okay,
So
isn't
it's a
it-
timing of
isn't it a
payment.
transfer? Isn't it a transfer of a pecuniary interest under a license? Because at least Wynn has a license, and Wynn is transferring the money to your client. So wouldn't Wynn be violating it if your client weren't?
No, Your Honor, because it's a transfer of money in exchange. It's the consideration that was agreed upon prior to the acquisition of the license. So if that were any
But
payment,
conditioned on that acquisition.
it's
So I will give you 1/3 of $40 million that the Gaming Commission says you can't have, if the Gaming Commission doesn't know about this transfer and gives me a license.
but it's not
Under the license? I
It's
don't-
not money generated by the license. If that were the
So
interpretation.
so your position is that the money needs to be generated by Wynn's casino operation?
Yes, Your Honor, it has to be either a transfer of the license or something that the license is used for. And that makes sense because the Anthony Gattineri is not subject to a suitability analysis. FBT was not subject to a suitability analysis. If someone's going to be the recipient
Well,
of something
Wynn's subject to the suitability analysis, and Wynn is hiding, arguably, that this premium is going to be paid that the Gambling Commission has decided cannot be paid because it raises too big a danger of organized crime being rewarded for the license, right? That's the Gambling Commission's very explicit and transparent. Whether it's permissible what they're doing is that other case. But they're very saying, look, we're not giving a license if someone with a felony conviction is going to profit from the casino premium. Not going to happen. We're not giving the license. And then your client and Wynn, according to you, agree that that's, despite what they say, we're going to get that premium, we're just not going to tell the Gambling Commission, right? Isn't that essentially the facts?
So, Your Honor, this is not, the consideration had nothing to do with the sale of the land. It had to do with the furnishing of a certification that Anthony Gattineri was not required to furnish at all. So it's not undermining.
I thought the Gambling Commission said, I want a certificate from all of these people, including your client, that there's, I can't remember, what's the certificate say?
The certificate requires the individual owners of FPT to certify that they're the sole recipients of the sale of the land proceeds. And Anthony signed that certificate, and it doesn't violate the condition going to Section 21C because the condition said you, Wynn, need to get those 3 certifications. Anthony Gattineri had no obligation to furnish the certification, and the condition did not say to Wynn, you cannot pay for the certification. This is not an increased payment for the sale of the land. The land, if you go to the land evidence records, it's still $35 million. Anthony Gattineri.
But he got his third of the $40 million premium that the commission said, we're not going to give you a license if you're going to pay that premium.
He negotiated
Of course.
what he thought was adequate consideration for the furnishing of the license, which included a whole host of things, including the fact that he was being referred for criminal investigation There were a number of reasons that went into why that consideration was agreed upon.
I thought your argument in federal court was it was specific enough because it related directly to the premium.
That was how it was calculated to make him whole, but a whole bunch of, it's a separate contract.
So it wasn't just, so that's the measure of its value was the premium that they wanted not paid. And that's why you say it's specific enough to be a contract, right?
That was the consideration that was agreed upon and how that figure was factored in, but a lot of different issues went into coming up with that consideration, but that is the number that was ultimately agreed upon. And with respect to...
So again, why don't you've got 4 minutes, I'm sure you'll probably go over, but address the public policy. The Gambling Commission, again, transparent. We do not want a premium paid to these people we're concerned about. We're not going to give Wynn the license if that's the case. And then it's concealed from them that that's exactly what is happening with your client. So isn't that a contract in violation of public policy, particularly in an incredibly heavily regulated world, which is the gambling world?
Your Honor, I would submit no. There's no violation of public policy. A public policy violation has to come from a statute. It has to be within what the legislature and the case law protects. And here, there's nothing in the gaming statute that allows the Gaming Commission to dictate what the consideration is to be paid with respect to the seller for the sale of the land on which the casino.
That was case number 1, right? You know, and maybe that's a taking, right? But we're now at case number 2. Isn't it a public policy problem for somebody to engage in this kind of self-help and say, you know, Gaming Commission, you did a taking on me, and what I'm going to do is go behind the scenes and get my fair share, make whole on what I was, you know, what was taken from me by the government.
Your Honor,
why would we allow that?
Anthony Gattineri was under no obligation to furnish the certification. He was not subject to the Gaming Act. He was not under any obligation to. So the fact that he received consideration for furnishing the certification does not violate public policy.
Even though the commission said, we don't want you to, as a condition precedent for issuing the license.
The commission, I would submit to the court, did not have the power.
Right, and that's a taking problem. That's why I said that's a case number 1 problem.
But if there's no statutory mechanism for the commission to control the purchase price for the sale of the property, if that's not something that's sanctioned by the statute, then this agreement, which is one step removed from that, can't violate public policy either.
But the integrity of the people they're dealing with, because they're going to be managing a gambling entity, and we have historic concerns about who runs a gambling facility. And that's all over the statute, right? The integrity of everyone they're dealing with, Wynn in particular, because Wynn has to sign this certificate, right? And so Wynn is potentially lying if he's doing this too, right? So isn't the integrity issue the public policy, the integrity of the representations being made to the Gambling Commission, the issue, right? That's a public policy.
But the money, so from Wynn's perspective, Wynn is not paying FPT a higher purchase price. It's not undermining that condition of licensure. It's not doing that. And the other thing that's going on here as well is...
No, it's Wynn has made representations that there's not going to be a gambling premium paid to people with felony convictions. We're not going to, because they're not going to get the license if that happens. And now you're saying they lied because they were paying your client a premium for that.
No, Your Honor, there's never been any felony conviction. In fact, Charlie Lightbody and Anthony Gattineri and Dustin
So they were
D'Annunzio.
acquitted, and that's a big part of the second case. But But that's not what the Gambling Commission was concerned about when they were giving out the license. I understand your argument that 21 may only deal with post-licensing behavior, and we're going to ask your sister that stuff. But the public policy deals with the integrity of representations made to the Gambling Commission for the purposes of getting a license, too, I would think.
Your Honor, and I know that's the other case, but the Gaming Commission accepted Wynn's proposal. It's unclear whether or not, I know this goes into the other case, whether or not it was something that it was mandated to do, but the Gaming Commission wouldn't have had the power to demand that the purchase price be $35 million. And in terms of the public policy behind
The Gaming Commission could have the power to unearth who exactly they're dealing with and find out whether any of them had criminal backgrounds. That was well within their power. They may not have exercised that power properly in the first case, but that was certainly well within their power to figure out exactly who they were dealing with.
Correct, Your Honor, that was within their power, but they didn't finish executing that power. And they give Wynn this windfall, so to speak, ostensibly because they're suspicious that there might be this hidden ownership interest. But if the whole point behind here is we don't want a convicted felon to profit from this transaction, they didn't accomplish that goal because the transfer of the property, assuming there was a hidden ownership interest, which has been disproven, still would have given a convicted felon an interest in the proceeds of the sale. So nothing about those conditions actually advanced any type of public policy under the Gaming Act. If I may, I think I have a few minutes left. I'd like to address a few of Wynn's arguments. And again, I just want to stress that the agreement had no impact on the purchase price of the Everett property at all. So in terms of the condition, there's no violation of the condition because the purchase price was dictated by the Ninth Amendment, which never changed. The payment was made in consideration of a certification. Anthony Gattineri had no ability whatsoever to impact that price for the purchase of the property. He couldn't change that. Even assuming that there could be an argument that the San Diego Agreement violates the Commission's approval conditions, these conditions themselves do not relate to or advance any public policy embodied in the Gaming Act. The public policy at issue here is ensuring the public confidence in the integrity of the gaming licensing process. The Commission, as I said a few minutes ago, ostensibly imposed those conditions on Wynn and FBT because they were concerned that Charlie Lightbody maintained some concealed interest in FBT and would therefore profit from the sale of the property. But nothing about those conditions advances the goal of ensuring public confidence in the integrity of the gaming licensing process. Even if Lightbody had a concealed interest in FBT, which was disproven, he still would have profited off of the Everett property sale. So therefore, there's no public policy advanced by that condition. Potentially preventing a convicted felon from profiting too much. Oh, I'm sorry.
Yeah, no, it's just that we're several minutes over and it looks like the material you're going over now may be in your brief.
Okay, thank you, Your Honor. I'll rest on our brief, and we request that the court answer the two certified questions with a resounding no. Thank you.
Okay. Attorney Musgrave.
Good morning, and may it please the court. Emily Musgrave on behalf of appellees Wynn MA LLC and Wynn Resorts Limited, and with me are my colleagues Tony Starr and Catherine Lombardo. This case asks the court to decide for the first time whether the Gaming Act will be enforced in the Commonwealth. The legislature could not have been clearer about the policy of this law. It is about transparency of process and has a quote-unquote paramount objective of, quote, ensuring public confidence in the integrity of the gaming licensing process, end quote.
Well, that's the second part. But could you go back to the first part for me? I found persuasive your sister's argument that there has to be an existing license for purposes of at least 21B and C. Can you go through the math for me as to how that provision could apply when the license was still extant?
Certainly, Your Honor. One of the conditions of the alleged San Diego agreement, and again, taking it as Gattineri alleges it, which we don't concede, was that Wynn would obtain the license. So the agreement did not spring into being until the license would have been issued. And at that point, it would have been a pecuniary payment under a license.
But the payment would be made before for the consideration for signing the certificate. So ostensibly, then the certificate would be used with the other FBT certificates, and that would be used as part of Wynn's application, and then ultimately they get the license. So it's still downstream from actually getting the license.
No, Your Honor, there were certain explicit conditions, and this is taken directly from Gattineri's complaint, which is that Wynn needed to obtain the license, Gattineri needed to be exonerated and so forth, but an explicit condition was obtaining the license before this agreement comes into being. So I don't agree that the payment would have preceded the issuance of the license.
Thank you.
Well, the license was a condition precedent to the payment. Is that what you're saying?
Obtaining the license,
Yeah,
yes.
but the
would have-
agreement was executed.
The agreement, to the extent it was, and again, we don't concede that, but to the extent the agreement was executed, there would have been the meeting of the minds, but the meeting of the minds contemplated the issuance of the license before the money would be paid.
Okay.
Although one thing about 21 kind of cuts against that is it's all about transfers of license, right? That's not really a transfer, it's the initial granting of the license, right? Because it seems like 21 is directed at, okay, we agreed to give you the license, you honest, good guy, but you transfer it to somebody who makes us really nervous, and they want to really be informed. Isn't most of 21 about transferring license?
I think 21B also contemplates a situation of that type of transfer, which is to say after a license is issued. But it doesn't preclude this situation, which is to say in connection with the license. And the reason I say that is because unlike the sections that surround 21B, which refer only to licensees, 21B explicitly refers to any person, not just any licensee. I also think, as the IEB suitability report demonstrates, the commission is established to be equally, if not more, concerned with the transparency of pecuniary interest under a gaming license before it finds an applicant suitable. So that reading is more consistent with the statutory text and the context in which it sits.
Why couldn't they just use the word you just used, applicant, instead of person? Why couldn't you say applicant?
Well, because I don't think it's just limited to the applicant. And I think 21B is designed to preclude exactly this type of interference with what is a heavily regulated process, not just by the applicant, but by any person who is soliciting or inducing even an applicant to try to transfer the interest under the license.
So on the public policy part, you don't spend any time on the other case, but I think maybe we need to do a little time on the other case. So if it wasn't proper to force this discount, does that present some problems for you? Mr. Gattineri says, I deserve this premium. You guys are shafting me out of that. You're taking my property unconstitutionally. Does that change the public policy analysis if it's problematic what the Gambling Commission did?
No, that case is completely unrelated. Whatever the commission did, whatever the commission's actions were, has no impact on the propriety of Gattineri resorting to this kind of self-help secret side deal designed to circumvent its process.
Meaning he should have sued you like the other, instead of doing the side deal where he gets his money in a hidden way, he should have done what the other members of this group did, which is sue the Gambling Commission. That was his proper way of getting paid, if it were improper to discount the amount.
I don't represent the Gaming Commission, but I don't intend to invite any lawsuits either.
Okay, that's right.
But
I
would
keep
say
forgetting
that,
your Wynn, not the.
Right.
Although you're involved in that lawsuit too, from what I understand, because they're blaming you for having done it.
Yes, Your Honor. But the point, I think, remains here, was that, yes, there are multiple pathways that would be open to Mr. Gattineri to challenge the commission's actions if that's what he sought to do. But our point is that the commission, for purposes of this case, could have done anything. They could have said that Wynn needs to put the Citgo sign on top of its casino, and if Mr. Gattineri were unhappy with that, it still wouldn't have been proper for him to execute a secret side deal and tell no one about it,
So
including
the problem
commission.
is the secrecy of the deal more than the substance of the deal.
Well, I think it's both, Your Honor. It's the secrecy of the deal, and it's the substance which goes directly to when the commission approved the Ninth Amendment, it did so with certain conditions, and the substance of this deal goes right to those. I do want to come back to the court's point. I think Your Honor said to force the discount, and since we are talking about the other case, I wanted to come back to that point. So just to be clear about what happened, under the original option agreement, there was a purchase price of $75 million with an undetermined amount of environmental remediation that needed to take place. Right. Under the Ninth Amendment, that allocation shifted. So the purchase price was 35.
But again, the purchase, the Gambling Commission's express, they're express. They say, we're not going to allow this casino premium, right? I understand the environmental may change the amount of money we're talking about, but there's an express refusal to allow, they wanted to make sure there was no possibility of this. And I'm focused on that because they may be running away, but the premium is associated with the number. There's a clear connection to what he wants to get paid relates to the premium, at least according to the federal case, because that's how they set the number. So, again, I understand the public policy concerns about lack of transparency, but I find the other part of it becomes a little more problematic. And I don't think you can just say, okay, it's really an environmental discount. Because it's not just really an environmental discount. It's don't pay these guys, because we want to make sure none of these people, including the plaintiff, gets a premium.
Your Honor, I wouldn't say it's an environmental discount. And when the environmental remediation was shifted over to Wynn by way of the Ninth Amendment, which is the agreement the parties agreed to and that the commission then approved, so I want to also be clear that didn't come from the commission. This isn't in the record, but in the parallel litigation, Wynn recently served in interrogatory responses totaling the approximate amount, excuse me, of environmental remediation that had to be accomplished.
So you're not going to say the whole $30 million is environmental, are you?
I'm not going to say that, Your Honor. I'm going to say it approximates $83 million, which is so substantial, in fact, that it dwarfs the original purchase price of $75 million. So that's why I say that when we look only at those two numbers, the 75 and the 35, that's misleading. I do come back, though, to the fundamental premise that none of that has anything to do with Mr. Gattineri's agreement, because whatever the commission did, he ought to have challenged it in a lawful way and not by means of self-help and a secret side deal.
Is Mr. Gattineri still part of FBT?
I don't know the status of that, Your Honor. I did see that appended to one of the amicus brief of FBT was that there was ongoing litigation among those members also.
Thank you.
Okay, looks like we're all set if you are.
If the court has no further questions, I'll rest on my briefs.